Good morning, sir. Can you see and hear me?
Yes, I can. Thank you.
Thank you very much. This morning we're going to hear from Mr. Clarke.
Yes.
If you'd like to repeat after me. I do solemnly,
sincerely and truly declare and affirm that the evidence that I shall give shall be the truth, the whole truth and nothing but the truth.
Thank you. You can sit down. Thanks. Thank you. Can you give your full name, please?
Simon Andrew Clarke.
Mr. Clarke, you should have in front of you a witness statement.
I have.
Is it dated the 23rd of March, 2024?
If you give me a moment. It is.
Could I ask you to turn to page 69?
I have it.
Is that your signature?
It is.
And is that statement true to the best of your knowledge and belief?
It is.
Thank you very much. That statement has the URN WITN 081301000. That statement will be published on the inquiry's website shortly. Mr. Clarke, many people in this room will already know, but you are a barrister.
Yep.
You were called to the bar in 1997.
Yep.
You practiced at the self-employed criminal bar until 2010.
I did.
And then you joined Cartwright King.
That's correct.
And you were based at Cartwright King until 2016.
Yes.
You then set up your own firm with Mr. Bowyer and Mr. Smith.
Yes.
Both of whom we've heard from. And like Mr. Smith, I think, did you have access to Cartwright King emails and electronic repositories at some point thereafter?
I did. We retained a consultancy with them, largely in the area of work that we'd set up the firm for, but also because they wanted from time to time additional help with the post office work they continued to do.
Thank you. You're still senior partner of that firm, is that correct?
The firm I set up, yes.
Yes. In terms of post office work, while you're at Cartwright King, is it right to say that you only undertook work for the post office after separation from Royal Mail Group?
Can I just add one other point first? I also practice at the independent bar. So,
Thank you.
Sure.
In addition to your own?
In addition to my own firm. In answer to your question, I joined Cartwright King in January of 2010 and effectively was General Defence Counsel for their clients. I was aware from just general background noise that they prosecuted for Royal Mail Group through Post Office. I was aware that Post Office separated in April, I think, 2012 from Royal Mail Group, but I didn't receive any instructions from the in-house head of advocacy to undertake any post office work substantively until about April, May 2013, although I did one or two brief mention hearings, I think, before that. So really 2013 was when my involvement started.
Thank you. What did you understand Cartwright King's role to be in relation to those post office cases? Were you an agent for the post office or something else?
Again, this is all from background noise. Pre-separation, I understood that Royal Mail Group had a number of agent solicitors across the country that they would ask to deal with matters in their own areas, prosecuting in the Magistrates' Court and instructing counsel in the Crown Court. Post-separation, Andy Cash at Cartwright King, one of the senior partners, had some links with Post Office, and he used those links to obtain a contract between Post Office and Cartwright King that Cartwright King would conduct all of the Post Office prosecutions across England and Wales from the 1st of April 2012. That was my understanding of the position. I know that to be the case because when I did get involved, I looked back to see what the position was.
And in terms of authority to make certain decisions in how cases are run, where did you see that lie? At Cartwright King or the Post Office, or a combination of the two?
Our function, as I saw it, and certainly my function, was to advise. And Post Office were responsible for taking the decisions because Post Office were the prosecuting authority.
And that is all fine in theory, but was that the reality?
There were times when Post Office didn't follow our advice, and there were times when they did. There were times when they were resistant to our advice. There were times when they accepted it. But you have to remember that from my point of view, I was only ever instructed to prosecute substantively a single case, and it was that case that effectively, I think, led us to where we are today. In my mind, certainly it is.
We see reference in your witness statement to being instructed by Andy Cash, who was the senior solicitor at Cartwright.
Yeah.
To what extent do you consider that you had to be specifically instructed to carry out that post office work in respect of individual pieces of work?
We use the word instructed generically. Andy Cash was, at the time, head of criminal advocacy. One of his functions was to allocate in-house Cartwright King cases and clients to particular barristers to work on, and Andy Cash allocated that case to me.
We've come to quite a few different advices that you wrote over the years. Sometimes it seems as though they weren't specifically requested by the post office.
No.
To what extent did you have autonomy to simply act as an effectively standing counsel to the post office?
I never saw myself as standing counsel to the post office. I was an employee of Cartwright King. I occasionally saw something that concerned me and advised because I was concerned, not because I had been specifically instructed to advise. And a good example is what happened in the Samra case.
Thank you. We'll get to the Samra case shortly. We've heard from Mr. Smith. The impression given by Mr. Smith that he relied on you for guidance and would in many ways defer to you. Is that impression correct?
No.
Why not?
Martin Smith was the communications route, if you like, the point of contact between Post Office and Cartwright King. And so everything I did, occasionally I would deal with Roderick Williams directly, but most of the time, everything I did and everything Harry Bowyer did went to Martin, who would then forward it to, I think, Jarnail Singh and or Roderick Williams, and occasionally, I think, other people in Post Office. So he was the main conduit between the two.
He may have been a main conduit, which is effectively how he described himself.
Yeah.
But in terms of actually responsibility, understanding, involvement in the underlying cases, do you agree or disagree with the evidence that he gave in that respect?
I disagree to an extent. Because Harry Bowyer and I were barristers, we tried to maintain the barrister-solicitor relationship. So Martin's description, if you like, could best be seen as the solicitor to the case. And if you want to formalise things and talk about who instructed who, Martin was effectively the instructing solicitor and was referred to that from time to time internally as the instructing solicitor on a case, with Andy Cash as the boss, if you like. But Martin would also give advice off of his own bat to Post Office from time to time. I know that because I've looked at the hearings and to my surprise have learned that in some respects.
What do you mean to your surprise?
Well, I knew he was speaking to Jarnail Singh. Jarnail Singh would phone him up extremely regularly, and he was speaking to Jarnail Singh and giving Jarnail Singh ad hoc advice on a daily basis. And occasionally, more than occasionally, Martin would come to us and say, Jarnail's asked this, what do you think? But quite often, Martin would give the advice himself. My surprise comes because I've seen a number of written documents where Martin appears to have been dealing directly with Andrew Parsons and Jarnail Singh separately or together without... I just don't recognise the documents.
You don't recognise the documents?
Yes, some that were put to him the other day.
So they may have been written but without being shared with yourself?
Yeah.
Mr. Smith also admitted certain shortcomings in his own knowledge.
I saw that.
Were you aware of that at the time?
No. Again, if I can clarify, I came in April, May 2013. By that time, Martin Smith and Andy Cash had been prosecuting for Post Office for quite a long time. And I had no knowledge of what they were and what they weren't doing during that period because I wasn't involved. So when I came in 2013 and stopped the prosecutions effectively from June onwards, I didn't look to see what Martin's state of knowledge was. I was more interested in repairing the damage which had plainly been caused.
Were you aware of any shortcomings in his legal knowledge?
He would ask me questions on law, and I would help him with them. I don't think there was any particular deficit that I can point to. I was surprised when he said the other day that he had no knowledge of prosecution disclosure duties because he was a defence solicitor.
I think post-conviction disclosure duties.
Well, it's not that different. The fundamental principles, as Brian Altman confirmed to us in advice, are the same. Is there material that might reasonably be expected to undermine the conviction such as to render it unsafe? I paraphrase, but by and large, it's the same principles. But the other point that concerned me, which did surprise me, is that the defence lawyers are expected to know prosecution duties of disclosure and prosecution duties vis-à-vis expert witnesses as well, because otherwise how can you properly defend your client in the face of disclosure issues or expert witness issues?
Paragraph 9 of your witness statement, you say that in late 2012 you were instructed to provide some general advice on prosecution procedures to Mr. Smith. Are we to understand that as training or something else?
It's, you'll forgive me, it's a slightly vague paragraph, and I think it's intended to be, because I recall giving advice. I do not recall giving training, and so it's likely, and I make a reference in the paragraph, I think, to written advice about, I may have provided written advice about evidential requirements in a particular case, but I don't recall. That, I think, is what I'm referring to. Martin would have given me a file and said, can you do me an advice on evidence, for instance? I think that's what I'm referring to. It's not training. I delivered no training to anybody.
And within Cartwright King, were you aware of any training about the role of a prosecutor, duties of disclosure, duties in respect of the instruction of expert witnesses? Or
prior to my involvement in May 2013, I just wouldn't know because I wasn't involved. There was none after, other than I've just said I didn't deliver any training. That's not strictly speaking true. After the Samra case, I gave training for the purposes of the SIFT process that you've heard about. I had to train those who were doing the first SIFT so they knew what they were looking for. But that was the extent of it.
Say, a solicitor who had conduct of a criminal prosecution? No.
No, I've just committed the offence of talking over you with the shorthand writer. I'm sorry. No.
Thank you. In terms of how the post office worked, in your experience of the post office, you say at paragraph 34 of your witness statement that the post office appears to work in silos.
You don't mind if I turn it up?
That's absolutely fine. I don't think we need to bring it onto screen.
No, it's here. Yeah. Yes.
Can you assist us with what you meant by the post office working in silos?
When I first raised the issues relating to expert witnesses with post office, they became very defensive in a general sense. When I spoke to people in post office on the telephone, I think we had a couple of meetings. I spoke with Roderick Williams, with Jarnail Singh, with Chris Oyard, and his predecessor, I think, was Susan Crichton. And I was aware of hearing around Cartwright King and around post office generally that people just weren't talking to each other. And as an example, Roderick Williams wouldn't know what post office security was doing. Jarnail Singh wouldn't have much communication with Roderick Williams. The investigation, this is all stuff I picked up, investigation teams weren't really talking to anybody substantively. Everybody was living in their own particular work environment, and there was no communication across the business, if you like. And it was quite frustrating because you would send an advice in, and a week or so later you would say to somebody, "You've seen my advice," and they would say, "Well, no." And you would then have to track down and find out why they hadn't seen it when you know they ought to have seen it. And it was largely because people weren't communicating with each other.
We'll come on to talk about the weekly meetings and the
Yeah.
central hub, but was that a theme that continued throughout your time at the post office, or?
It was. It got worse, I think. One of the reasons why I advised that the weekly hub meetings were convened was to cure this problem, was to make people speak to each other about Horizon in particular, because I rather suspected at the time, I know better now, but at the time I rather suspected that one of the reasons why these 2 Horizon bugs detected by Second Sight escaped people's attention was because nobody was talking to each other. As simple as that.
And what do you put that down to fundamentally?
Office politics? I don't know. It's speculative. It became something more after the event, but at the time I was encountering it in June, July, August of 2013. I put it down to office politics. People were working within their own comfort zones. And never the twain shall meet, as they say.
I'm going to take you to another passage from your statement. So it's WITN 081301000. And if we could look at page 47, paragraph 138, please.
Can I just read it?
You can. I'm going to bring it onto screen as
Okay.
well, please. Thanks. It's page 47. And it's the second half of paragraph 138 that I
know
want
what
to
you're
take you to. You say there, looking back,
Yeah.
I now see what appears to have been 3 strands of thought within the post office on the topic of disclosure. The first strand amounted to an article of faith. Horizon is both robust and reliable. There is nothing wrong with it, and if Horizon says money is missing, then it is missing. The second strand considered that the cost of providing disclosure was prohibitive and should always be discouraged. The third strand, I felt, arose out of an almost religious panic. Horizon must not be seen to have been impugned. Now, at least the second strand and the third strand there were presumably things you knew from quite an early stage. As in, you were aware that they were concerned about the cost,
Yes.
And you were also aware that they were very resistant to allegations about the reliability of Horizon.
I agree.
In terms of one, we know that you certainly found out that it wasn't accurate at the latest by the phone conversation that you had with Gareth Jenkins and the Second Sight report. You look reluctant.
Just slightly. You say I certainly found out. That was when I learned that there were bugs in the system. That at the time didn't necessarily speak to the general unreliability of Horizon, because we were still hearing that the systems that were in place to deal with bugs, this is what we were told on the day we were told that there was, on the 27th of June, I think, that there was a potential for bugs, that there was nothing fundamentally wrong with Horizon. So I would suggest that a better take on that phone call would be, I had concerns because I had been told, I think by Martin Smith, that Second Sight had identified 2 bugs and were to publish this report. And my instinctive reaction was, we need to find out who told Second Sight about those bugs, which is why I asked for the call to be made to Gareth Jenkins the following day.
And we'll come to that call, but in terms of, you've used the word fundamental just now, in terms of nothing fundamentally wrong.
Yeah.
Your first strand here is there is nothing wrong with it. And if Horizon says money is missing, then it's missing.
Yeah.
By at least the time you had spoken to Gareth Jenkins, you knew that that couldn't have been correct.
Yeah, I think that's probably right. Yeah.
Thank you. You've been very clear in your evidence just now and also in your statement about various failings at the post office. Do you think that you also might have taken too tough a stance, particularly in relation to disclosure to sub-postmasters?
I think that's arguable, yes.
We'll come and look at it over time. Let's start in late June, early July 2013. That can come off the screen, please. You say that you first became aware of bugs on the 27th of June 2013 when you were told about the second site interim report by Martin Smith. Can you just elaborate on that slightly?
We had heard, and I don't know whether it's that day or not, but we would heard very close in time to me being told that Post Office had commissioned an organisation called Second Sight to look into Horizon, and that they had done so as a result, I think, and this is anecdotal, of pressure from Justice for Sub-Postmasters organisation or the like. And the messages we were getting back from Post Office round about 25, 26 June were, we've got nothing to worry about, Second Sight are going to give it a clean bill of health. 27th of June, I think Martin must have had some contact with either Jarnell Singh or Roderick Williams, because he then came to me, and I think, I can't say where we were or what we were doing, it might have been by telephone, it might have been in person, but he said to me, Second Sight are going to say there are 2 bugs. And that really was the extent of it, and my immediate reaction was, who told them? And the reason who told them was so important was because if it were the expert that they were relying on to give evidence, then his evidence had not been entirely complete.
Was that an immediate thought as early as the 27th of June?
Oh yes, oh yes. To be told that there were that the report was going to tell us that there were bugs in the system is a process stopping mechanism. You can't go anywhere from that other than to say, well, how? Why? Who told them? Because your duties as a prosecutor are so absolute in those circumstances that any competent barrister is going to say, whoa, stop. We have to see what's going on here.
You say in your statement that you saw the Helen Rose report soon after.
Yep.
That report was written on the 12th of June 2013.
Yeah.
It identified issues at the Lepton branch.
Yep.
It included certain correspondence with Gareth Jenkins, and there was a mention in it of Horizon integrity issues.
Yep.
Can you assist us at all with when you are likely to have seen that? Was it before the conversation with Gareth Jenkins?
No, it was after.
It was after.
I know it was after because up until that point, Horizon was, I don't mock, but Horizon was robust. Its integrity was sound. It worked perfectly. What put me on notice that it might not have done was the conversation with Martin Smith that there were bugs in the system as per Second Sight. Had I had the Lepton report prior to that, then my reaction that occurred on the 27th of June would have occurred when I first saw the Helen Rose report. It's that report that reinforced my view that there was something seriously wrong. So I would have seen it after I was told by Martin Smith about this.
Within a week? Within 2 weeks?
Well, do I refer to it in my July 15 advice?
We'll come to look at that.
Well, if I refer it to, I mean, I'm not going to get into I don't remember, but if I refer to it in my July 15 advice, then I had it before July 15. If I don't, then I had it after.
Thank you. Let's look at the phone call with Gareth Jenkins. That's at poll 001422322. And that's the 28th of June.
Yeah.
So Mr. Smith has told you on the 27th about the potential bugs.
Yeah.
Was there a conversation with anyone at the post office before this conversation took place?
Well, I asked Martin to set this call up. I imagine he contacted Jarnell Singh for the contact details. I don't know what he said to them.
There was no conversation on your part
No.
with the post office?
No.
Did you have a long conversation with Mr. Smith before this call?
I don't believe so. My reaction was, we need to speak to the expert. Can you set it up, please? I'm pretty sure is the way it would have gone.
You said that it was very clear that there was a problem with Gareth Jenkins on the 27th.
Yeah.
Can you recall Mr. Smith's position?
No, forgive me. There wasn't a problem with Gareth Jenkins on the 27th. There was a problem that indicated there were bugs with Horizon. My concern and the reason for the Gareth Jenkins call was to find out who told Second Sight. Because I think the language in the Second Sight report was, we have been informed. And
I think
I
your
wanted
evidence...
to know who the informant was. And my first port of call was to ask the expert. And it was only when I spoke to the expert during this call that I realised the problem lay with Gareth Jenkins.
I had understood your earlier evidence to be that when you were aware of the bugs on the 27th, that immediately caused you to be concerned about the reliability of Mr. Jenkins.
Yes.
Thank you. And what about Mr. Smith? Was he as concerned as you about Mr. Jenkins or not?
I don't think we had, vague recollection, I don't think we had much of a conversation about it. I'm not convinced that Martin Smith appreciated the full import of the problem at that point.
I'm going to read to you some passages from this transcript.
Please.
So you say, hi, is that Gareth Jenkins? He says, it is indeed. And you say, oh, hi, Gareth, it's Simon Clarke. I'm a barrister prosecuting a case for Jarnell on Monday at Birmingham Crown Court. And that's the Samra case.
Yes.
And he says, right. And you say, Jarnell suggested that we give you a call because we've heard that the Insight Committee report is due to go before MPs next week. I don't know if you've heard the same thing, have you? And he says 8th of July is the date I've been told. Just pausing there, Jarnell suggested that we give you a call. Was it Jarnell's suggestion or?
It was mine.
Was that a way of you?
So I'm speaking over you. Carry on.
Can you assist us with why you said that Jarnell had suggested?
It's likely a rhetorical device to open the conversation with Gareth Jenkins.
If we scroll down, please. You say, okay, well, can I give you a brief sort of thumbnail sketch? Basically, this is a postmistress who is alleged to have made double transaction withdrawals from Horizon when people have come in and taken money out of the post office card accounts. Do you follow? And he says, yes, I think I've heard about that sort of scam going on, yes. And you say yes, and essentially what she is doing, she is asking them to put their PIN number in a second time, claiming it hasn't worked the first time, and accordingly then taking the money out herself. Yep. And then you say, all of the evidence we've got against her is Horizon data evidence. And he says, yep. And then you say, and when I say that, what I mean is that all the transactions are conducted over the counter through Horizon. And he says, yep. I'll skip the next bit. You then go on to say, okay, the problem I have got is that we're not allowed to see the report, but we're told that there are up to 30 offices where bugs have been identified, yeah? And we know that Hurst Lane is not one of the branches where has been an identified bug. Still with us. He says, right, as I say, certainly I'm aware of 2 bugs. Firstly, is this something that has been done on Horizon, on the new Horizon system or the old system? And you say and he says, what's the date? And you say it's Horizon Online. He then says, okay, right, so there is 2 bugs that we have declared to Second Sight in that sort of, and we know exactly which branches are affected, and they wouldn't have any impact whatsoever on that part of what's going on. And I think we are confident that the audit trail that you're using for the prosecution has not been compromised by those bugs. Just pausing there, 2 bugs that we have declared to Second Sight. Did that cause you any concern, suspicion?
That confirmed to me that it was Gareth Jenkins that had told Second Sight about the bugs, and more importantly, that he knew about them.
If we scroll over the page, please. You say, what I'm looking for is confirmation effectively that you have given. So can I ask you a couple of questions which may prompt yes or no answers? And he says, sure. Did you have a script ready, or was this, no, just off the top of your head?
Sorry, I'm indicating off the top of my head.
The stenographer will have difficulty
about the
typing.
Yeah.
your hand signal. You say, as far as the data that the transactions conducted over Horizon, which include the withdrawal of sums of cash from post office card accounts, is there any reason to believe that Horizon can slip into error? And he says, not that I'm aware of. And then if we scroll down, you then say, okay, where are we going from here? What's the question I posed earlier? Sorry, I've got Martin Smith, and you introduce Martin Smith at that point, who he acknowledges. And then he says, hi, it's the Horizon system is functioning perfectly. And then you say, this is the other point. Bugs have been identified in Horizon which call into question some of the aspects of the way in which it operates. That's a fair assessment, isn't it? And Mr. Jenkins says, yes. And then you say, yep, okay, how can we be sure that A, we have identified all of the bugs that there are, and B, that although Horizon has been demonstrated that to be fallible, that insofar as the case we are conducting is concerned, we can eliminate the possibility of error? And he says there, right, I mean, clearly we can't. You can never say there are no more bugs in the system, so we've got to be careful about trying to say anything like that. Just pausing there. Any reaction from you?
Now, well, the problem is that's what he's been saying in all of his previous reports. You'll recall that after this telephone conversation, I asked Martin to provide me with half a dozen of his previous statements, and what he was saying in his previous statements was absolutely contrary to what he's just said here.
And then he says, but what we can show is that nothing has been found to show that there is a problem in the integrity of the audit trail, which is what has been used for your evidence. And you say, so your view is that that if the defence were to suggest there is a problem with Horizon, and therefore we can't rule out that there might be other problems with Horizon, what you say is, as far as you're concerned, the integrity of the system is intact. And he says, yes. So just summarising that conversation, it seems as though there are two bugs that you hadn't previously been aware of, that he has confirmed exist, and also that he can't say that there aren't more bugs in the system.
There's a third strand which to me was the most important, and that was that he knew at the time of this conversation and beforehand that those bugs were extant because it was he who had informed Second Sight of them. And that, to me, was the most important element of that conversation.
Putting those all together, was that quite a bombshell moment for you?
Yes, it was.
Is this the first time in your career where a conversation with a witness has been recorded in this way? Or is it at least unusual for you to have recorded it?
It's unusual, but it's not the first time.
Why did you feel it was necessary to record it?
I thought it was hugely important that we knew who told Second Sight of the bugs, because if it had been Fujitsu or Gareth Jenkins, then frankly Gareth Jenkins was in trouble. And I needed a record of what was said. And just so that you understand the position, because when you sent this document to me, you didn't know who the author was or what the conversation was about, and I explained it in my witness statement. I had said to Martin Smith, we ought to record this. He recorded it on his mobile telephone, and then I said to him, can you transcribe it, please? And clearly you've located it in the records. And frankly, thank goodness I said that.
We're going to come in due course to formal advice that was written on this issue. But did you, at that point, have another conversation with somebody at the post office?
Oh, possibly with Jarnail Singh. I certainly told somebody at post office orally. I don't think it would have been Roderick Williams, because at that point I had no contact with him. I hardly knew who he was. So if anybody, it would have been Jarnail Singh. It's highly likely that I would have said to him on the telephone, you've got problems. And I would have explained the nature of the problem to him.
Do you think it's likely that you spoke to anybody else at that point, or
No.
just Jarnail Singh?
No, the only person I knew at Post Office at that time was Jarnail Singh, and I didn't actually know him. I just knew he was the contact for Martin Smith.
We're now going to come to the case of Samra, and there is a hearing a few days after that conversation on the 1st of July.
Day listed for trial.
Yes. Can we please bring up onto screen poll 00172804? I'm going to spend a bit of time on your attendance note from that
cool.
hearing. If we scroll down, this is a hearing note written by yourself.
Yes. If I signed it, it's mine.
Yes, it has your name at the bottom,
Yep.
1st of July 2013. And there's some background to the case at the top. Paragraph 2 I'll read. That says, all of the duplicate transactions were conducted over the counter through Horizon, this being the only portal through which post office card accounts may be conducted. Accordingly, transactions are evidenced through entries appearing in post office card account statements. Those entries represent Horizon data. That's effectively what you told Mr. Jenkins in that conversation, that the evidence was fundamentally relying on Horizon data.
I cringed if you saw, because I hate using the word evidenced as a verb, but yes.
If we scroll down, please, to the bottom of paragraph 3, you say there, further, whilst she has not directly suggested that Horizon data is wrong, there is an implicit suggestion that if the complainant's account of not having made duplicate transactions is correct, then the fault must lie with Horizon. So an acknowledgement from yourself that although it hadn't been pleaded, it was
follows.
Something that was highly relevant to that trial. Recent information, paragraph 4. The limited information available to me comes from a number of sources within Post Office Limited. Head of Litigation Hugh Flemington, Head of Criminal Law Jarnail Singh, and Gareth Jenkins of Fujitsu Services Limited. We've heard you talk about Jarnail Singh, we've heard you talk about Gareth Jenkins. Can you assist us with any conversation you had with Hugh Flemington at this time?
I don't believe I have ever spoken with Hugh Flemington. I saw him the other day and didn't recognise him. Information from Hugh Flemington, if I had had any, and it's likely I had because of this, would have come through Jarnail Singh.
Thank you. You say, I first became of the issue of bugs within the Horizon system on the 27th of June, exactly as we've just been discussing.
Yep.
And it indicated that the second site report indicated that Horizon may not be bug-free. I'm instructed that the report is to be provided to Parliament prior to publication, perhaps as early as Monday, the 1st of July. I have not seen the report. Prior to the 27th of June, I had seen no reference in any of the expert reports tendered for the prosecution in other cases to the existence or possible existence of bugs. On the 27th of June, and through the following day, I was instructed that in a number of post offices, the Horizon system may have produced false balances. And then you say that you are informed of the following. And one, if we scroll down, please, over the page. All of the information used by Hewlett-Packard is derived directly from Horizon. Horizon is not bug-free. Fujitsu Services Limited had reported the existence of 2 bugs to the Second Site Committee. A number of bugs have been identified which have affected a number of post offices, although it is not clear to me that those are the same as disclosed to the Second Site Committee by Fujitsu. Now, is that a reference to the Helen Rose report or to some other conversation or to that Gareth Jenkins conversation?
No, it's more basic than that. Fujitsu gave the bugs names. I think they gave a bug a name called Bug 64, and then another bug was called the Calendar Square bug, and then there was something else called the Falkirk bug, and then somebody told me that the Falkirk bug was the Calendar Square bug. So it was a confusion in their naming of the bugs which caused this paragraph, which made me not sure whether there were two or more.
And where did that confusion come from? Can you recall who the conversation was with?
Again, most of this would have come through, in fact, I mentioned it there, bug 68. Most of it would have come through Jarnail Singh and through him via Martin Smith or directly.
You then say, the two bugs I'm instructed of by the post office are bug 14, so-called because it affected 14 post offices, and bug 68, named for similar reasons, question mark. So you weren't clear whether that was the number of branches affected or some other reason. It could, in theory, have been the 68th bug that they found.
Yeah, this exemplifies the confusion.
6, the effect of bug 14 has been the appearance of incorrect financial balance information in the system, known to include the false indication of financial data. Hurst Lane Post Office, so that's the one in this particular case, is not one of those post offices identified as having been affected. The report's authors were instructed to investigate a number of cases of apparent Horizon error, including at least one where prosecution was contemplated. That prosecution would have relied heavily upon data obtained from Horizon. Now, I don't think that is information that we saw in that Gareth Jenkins recording. Do you know where that information came from?
Again, it would have come through Jarnail Singh, possibly from people behind him.
Paragraph 7. Once we became aware of the timetable for publication of the Second Sight report and its preview to Parliament, Martin Smith and I, and with Head of Criminal Law, Jarnail Singh's agreement, contacted Gareth Jenkins in order to establish what was known about the status of Horizon integrity. So it seems as though there was a conversation with Jarnail Singh where he agreed to you phoning up.
I accept that. Yeah.
There's then a summary of the phone call. I'm not going to go through those points. We've already read the transcript. Could we scroll down to paragraph 8, please? You say, the information may be distilled thus. Fujitsu Services Limited and Post Office Limited are aware that Horizon has suffered bug 68 and bug 14. It is highly likely that the two bugs reported to Second Sight by Fujitsu are bugs 14 and 68. One bug has been neutralized, the other remains extant. The extant bug affects Horizon to a limited degree, and at specific post office locations, it manifests itself by producing false balances. Whilst Fujitsu Services Limited continue to have faith in the integrity of Horizon, and whilst there is no other indication of any more bugs, further possible bugs within Horizon cannot be ruled out. Similar words, those used by Gareth Jenkins in that conversation.
And forgive me, it's stating the obvious.
If we please go over to page 6, paragraph 14. This is, you address the law of disclosure, and then you go on to address public interest immunity. Yeah. And you say at paragraph 14, in some circumstances, it is possible to apply to a judge for a certificate not to disclose material to the defence where that material was subject to a public interest immunity. Such applications most often occur in cases involving national security or where police have used informants and undercover officers. The list of such cases, however, is not closed. In a case where the public interest may be the prevention of a widespread loss of confidence in a public institution, or the loss of trust in a system operated by such an institution, or the prevention of journalistic speculation as to the efficacy of systems almost universally relied upon by the public, there may be an argument that the protection of a public interest immunity certificate is appropriate. PII hearings are always held in chambers, that is, in the absence of any defendant or defence representative, and usually in the judge's chambers, retiring room. No other person may be present other than a court clerk, any relevant police officer, and the prosecuting solicitor. Over the page, please. You say, in this case, I took the view that such an approach to the problem might be appropriate. Accordingly, Martin Smith and I, in conjunction with Jarnail Singh, decided that the best way forward was to seek a ruling, the grant of a PII certificate from the trial judge, that we need not disclose to the defence the fact that the second site report was to be presented to Parliament today, and that the report contained references to the existence of bugs in Horizon, both past and present, and two, to adjourn the trial until such time as we were able to fully comply with our disclosure duties. First of all, can I just ask, that hearing took place in the absence of notice to the defendant, is that correct?
That's not correct.
That's not correct?
No. It is common practice amongst counsel that if a PI application is to be made, that defending counsel will be informed informally at court by prosecuting counsel, and that's what I did.
So you informed defence counsel and then had the PII hearing?
Yeah. And can I just add to that, the proposition that I could just go and see the judge without telling defence counsel would, at the very least, have prompted defence counsel to say, what's going on? So defence counsel would have had to have been informed, and he was.
If we scroll down paragraph 17, the effect of the late development in this case is that we could not commence this trial as scheduled. To do so would be to mislead the court into believing that we had complied with our duties as prosecutor, and that we cannot contemplate.
Yes.
There isn't detail here about what the judge was actually told.
No.
Can you assist us with what, I mean, we see paragraph 14, for example, about the possible heads of public interest immunity that could be argued. What was it that you were saying to the judge in chambers that persuaded him to grant a PII certificate?
Pretty much what we knew. I told the judge that about the issue with the expert, that bugs had been identified, that we could no longer rely on our expert. I told the judge that there was a report due to be published to MPs, and something that had been impressed upon me by Post Office through Jarnail Singh was the issue of parliamentary privilege. It is possible that it would have been a breach of parliamentary privilege to have effectively produced the report before Parliament had released it for production. I told the judge that, and that really was the basis of the application. I wanted to comply with my disclosure duties, but I couldn't on that day, largely because I believed parliamentary privilege prevented me from doing so. And so that's what I said to the judge.
You've said in paragraph 14 that a potential argument could be made about journalistic speculation about the system. Was that something that was raised before the judge?
It would have been. What I've raised, I'm reluctant just to settle on just one point in paragraph 14 as a single compelling point. The overall issue was all of them taken together suggested to me that publishing the report to the defence at that time would be inappropriate.
Paragraph 18 then says the judge, His Honour Judge Chambers, was ultimately persuaded of the arguments advanced in support of the grant of the certificate, and then certain orders were made.
Yep.
Defence to be told that a report had been commissioned, prosecution to be permitted to withhold information, non-disclosure order to be temporary and reviewed at a mention hearing, and adjournment for 8 weeks. If we scroll over the page...
But before you do that, can I just say that is everything I asked for from the judge. I did not want a PII certificate that prevented disclosure completely. I was looking to buy time so that Parliament could deal with the report and I could then comply with my disclosure duties. And that's why the judge timed it. I think he limited it to 8 weeks. I asked for less, but I think he gave me 8 weeks.
Yes, well, the case was adjourned for 8 weeks.
Yeah. But I only wanted a short period in order to allow for the publication of the report so that I could then comply, without worrying about what Parliament was doing, comply with my disclosure duties.
Paragraph 19, the judge also commented that this situation should never have arisen and that the Post Office were to provide a written explanation as to why this information had been withheld from solicitors and counsel until as late as last Thursday. So it seems as though you explained to the judge that this was all news to you.
Yes, I'd only learnt a few days before. I smiled because he was a bit more scathing about the situation than that paragraph suggests. He was quite upset.
And that's because a trial was due to take place that had to be vacated, or some other reason?
Not just because effectively we were wasting the court's time by aborting a trial that was due to start that day, but because the prosecution had plainly not done that which they ought to have done in time for the trial.
Paragraph 20, you provide a comment and conclusion. You say, I'm not particularly concerned at the judge's requirement for a written explanation from the Post Office. To a large degree, the heads of litigation and criminal law were in much the same position as were Martin Smith and I, and accordingly I have no difficulty in assisting with the preparation of an explanation. You say there the heads of litigation and criminal law were in the same position. What did you mean by that?
That's what I've been told, that they'd only just discovered the existence of the bugs at roughly the same time that I did. And if that was right, then they were in the same position we were.
And was that a specific conversation with the heads of litigation and the head of criminal law?
No, it would all have come through John Elsing.
Thank you. Paragraph 21, you say, of greater concern is the absence of any reference to bug 68 or bug 14 in any of Fujitsu Service Limited's statements served in support of other criminal prosecutions. This is a matter to be returned to at the appropriate time. So this is your concern about the potential impact on historic cases that relied on Gareth Jenkins' evidence.
It is, and I think what I'm doing here is flagging up that I'm going to advise, as I did on the 8th of July and the 15th of July. I think I'm sort of pointing in that direction.
Was that something that you mentioned to the judge at the PI hearing, that there were concerns about a witness who had been used in previous?
Oh, yes.
Yes.
It would have been wrong to withhold that.
If we scroll down and over the page, please. Paragraph 23 says, it is also the case that we shall have to review any other prosecution which relies upon Horizon data for the same reasons. So you're flagging there what became ultimately your review.
Yeah, to a degree, the writing of these documents involves a thought process which helps you to marshal where you want to go. And that's, I suspect that's the beginning of me thinking we need to go wider than this case.
And paragraph 24 says, finally, it's worth commenting on the reasoning behind my advice that we seek a PII certificate in this case. The Post Office were, rightly in my opinion, very concerned at the potential adverse publicity which would inevitably have been generated by the revelation of the existence of a draft second sight report into Horizon. To permit this information to enter the public domain at such an early stage would have been to encourage extremely unhealthy and likely virulent speculation as to the content of any report, most probably in the national press. Such speculation would have seriously damaged the reputation of the Post Office and would have greatly undermined public confidence in both the Post Office and the Post Office systems. Our objective was to avoid such consequences. That objective we achieved. Now, that isn't anything about parliamentary privilege. That is about publicity and avoiding publicity. So do you accept that a significant part of the reasoning behind seeking that certificate was to avoid speculation and publicity?
I do.
Looking back at it, do you think it was a proper application to have been made?
Yes. I would go so far as to say if I were in the same situation now, with the same information I had, I would make that application again. That is, if there was a report which was subject to parliamentary privilege, and it was important that Parliament saw the report first, and we've all seen in the press the number of times Parliament has complained about people saying things before going to Parliament, I would make the application again. I consider that the issues that I had raised fell squarely within the main authority on the subject, which was Re-H and Re-C, where it suggested that the categories to which public interest immunity applied were not closed, and I thought this was a proper category to make the application.
Mr. Clarke, that all sounds very reasonable, but paragraph 24 does not mention at all parliamentary privilege. Paragraph 24 is very much about the reputation of the Post Office and undermining public confidence in both the Post Office and Post Office systems. It doesn't say anything about privilege.
I agree, but to an extent I disagree with you about the import of paragraph 24. One of the things we were concerned with, it wasn't just it wasn't just parliamentary privilege we were concerned with, we were also concerned with, because I made the application and I advised the application be made, I was concerned with the proposition that if the existence of the report and the existence of the suggestion that there were bugs in Horizon had come out before the report had been presented to Parliament, then the speculation would be damaging not just to Post Office, but to the entire financial system upon which Post Office was based. Because the speculation could be inaccurate, it could be wild, for all the reasons I suggest here.
Insofar as your application was in fact based on parliamentary privilege, is this paragraph here something that we are all guilty of, which is perhaps gloating in an attendance note about something that you know the client would be happy about?
I hate the word gloating, but I think you're probably right. Yeah.
That's the 1st of July.
Could I just make the point, which I think is quite important, is that the judge did grant the application. And so the suggestion that it was an improper application, I would go so far as to suggest can't stand, because the judge granted it and the judge therefore felt that it was a proper application to make. That sounds slightly defensive, but it's a point I make, because had it been an improper application, the judge would have said, I'm not granting this.
What we don't have is the information the judge was presented with. I haven't made a suggestion that it was an improper application. But what I would suggest is that paragraph 24, looking at that, it seems as though the objective that is set out in paragraph 24 is not itself a proper objective to make a PII application.
I think I agree with that. The reason I speak about the propriety of the application is I have heard it suggested elsewhere, and perhaps I'm getting ahead of myself and shouldn't.
You're protecting yourself from Mr. Maloney, which is...
Well, I suppose if you want to put it that way, yes. I saw what Mr. Maloney asked of Martin Smith, and I disagreed quite seriously with the propositions that were being put.
Yes, Mr. Maloney didn't suggest it was improper, just to...
Oh, fine, then thank you, I'm happy.
In your witness statement, paragraphs 43 and 44, you say that you went to the Post Office's offices on the 3rd of July, so a couple of days after this hearing.
Yeah, if that's what it says, yeah.
I think you say in your statement, most likely with Roderick Williams and Jarnell Singh. Are you able to assist us at all with how likely that is?
Very likely. I would have had to have met him very early on, and so I suspect it was almost inevitable that I would have met him at that meeting. I can't think of a reason why I wouldn't have met him at that meeting. It makes absolute sense.
When you say him, we know you've had conversations with Jarnell Singh.
Yep.
What about Roderick Williams?
No, that's what I'm saying. I think it's inevitable that that's when I first met Roderick Williams.
Thank you.
I think that's absolutely right.
I think
Mr. Blake, what numbered paragraph was that? Did you just
43 and 44.
43 and 44, thank you.
Am I right in saying you say you never met Hugh Flemington?
I have no recollection of ever having met him. He may have been in a room with me, I don't know. I did not recognise him when I saw him on the screen the other day. I can't put it any higher than that.
Thank you. And it's at that meeting that you advised that there should be the central hub, I think, later followed up in writing.
Likely, yes, I think that's right.
Did you, at that meeting with Roderick Williams, explain the real concerns that you have explained to us about Gareth Jenkins?
Yes. That was the point of the meeting.
And what was the reaction to that? What do you recall of the reaction to that?
I expected surprise, shock, horror. I did not see any of those things. He appeared to me to be taking it into his stride, and his concern was with where we went from here.
Did it seem as though you weren't providing him with new information?
I think it would be unfair to say that. I can't look into his mind. All I can say is I did not see the surprise and astonishment I expected.
Do we need to stop now? I'm just thinking about a mid-morning break. I'm coming to a point, but I think let's go on with... actually, no, sir, I think it's, if we're going to take 2 morning breaks, I think now is actually an appropriate time.
All right, that's fine. Rather than say 10:58, let's say 11 o'clock, yeah?
I think it's only a 10-minute... Oh, yes.
Yeah, I'm giving you 12 minutes, Mr. Blake.
Thank you very much, sir. Thank you, sir. Can you see and hear me?
Yes, yes.
Thank you. Mr. Clarke, we left off on the case of Samra. It's right to say that in that case you had disclosable information about bugs, errors and defects in Horizon, correct?
Correct?
It was a case that involved Horizon.
Yes?
It's a case that the effectiveness or inadequacy of Horizon could have affected the outcome.
Yes?
Public interest immunity enabled that information to be hidden from the public for the time being.
Yes, for a limited period.
And the result was that you didn't need to say in open court something that you would have had to have said had that not taken place via the PII mechanism.
No, I don't think I would have had to have said it in open court. I simply would have had to have disclosed the material to the defence, and then they would have made what they would of it.
Exactly. So it would have been used in open court.
Yes.
Had it not been covered by the envelope of public interest immunity.
Yeah, that's correct.
I'm going to move on to what happened to cases where there had been convictions or ongoing prosecutions or some ongoing actions and disclosure that was or wasn't made in those cases. Can we please look at poll 001-45145, please? Thank you. If we please could look at page 5. This is the very same day as that public interest immunity hearing. We have an email from Andrew Parsons. If we scroll down to, it's an internal email, but you'll see it's forwarded to you. He attaches 10 letters to sub-postmasters for review. Are you aware? I'll take you to the letters, but I think you've seen them quite recently. They are letters about a bug called B14. Do you recall that issue?
Vaguely, yes.
Yes.
I've seen the documents recently, yes.
And Mr. Parsons sends certain sub-postmasters from those 14 branches letters disclosing that issue. Could we please turn to page 1? It's what we know as the local suspense account issue.
Okay.
And if we look at the bottom of that page, please, we have an email from Roderick Williams to yourself and to Martin Smith. And he says, Simon, Martin, 2 issues from the conference today. So it seems as though you had a conference on the 3rd of July. In fact, that's the one that we just talked about, is it?
Yep.
So we know, as we see, I mean, it's copied to Hugh Flemington. Does that indicate in any way that Hugh Flemington might have been at that meeting?
No, he was copied into lots and lots of emails, I think for information purposes. As I understood it, he was, I may be wrong, I think he was head of legal at Post Office, so it's not surprising he was copied into everything.
Number 1, letters to branches. I attach the letters we propose sending to the branches affected by B14. And then he refers to the Merthyr Diffan letter, which concerns the cost cutter branch, which might have involved a police prosecution of a branch assistant. They're no clearer on the status of that investigation/prosecution. And if we look at the final paragraph on that page, it says, during our conference, you explained prosecuting counsel's duty of disclosure. Please also let us know whether we could satisfy our duty of disclosure, i.e. that we know of an issue which might be relevant to criminal proceedings by notifying the police/cost cutter prosecuting counsel of B14 so that they can take a view on whether they should disclose it to the defence according to their duty. Your response is at the top of the page. And you respond as follows. All letters. Is it necessary to inform each of the officers of the fact that other branches are affected? It seems to me that these letters will somehow get in the public domain. Justice for Sub-Postmasters Alliance? ? If that were to happen, then again we run the risk of adverse speculation, at least until Second Sight is published, if it is to be. Very much echoing what was said at the end of that attendance note about adverse publicity, adverse speculation. It does seem as though you were, as at the 4th of July, particularly concerned with limiting adverse speculation.
I agree.
Merthyr Diffan, in this case, there are competing interests, open and transparent dealing by the Post Office as against the proposition that this is likely to be an appeal case. Could you hold off on this letter for a short while? I will come back to you this afternoon once I've more fully considered the position and seen what the Post Office have forwarded to Martin Smith. Now, you've explained in your statement that this was some sort of concern about the sub-justice rule. Can you assist us with
Sub-judice rule?
Yes.
Probably not that. I've always been very cautious about the Court of Appeal and involvement in potential appeals because, as far as I'm concerned, the Court of Appeal is the final arbiter in whether or not convictions are safe or otherwise. And so I'm always very careful to this day, I'm very careful about what I do and say in the knowledge that the Court of Appeal may end up reviewing what's been done. So I always approach issues of appeal with caution. And that's what I'm doing here.
You've described these as competing interests. So on the one hand, you have being open and transparent.
Yep.
On the other hand, you have the potential impact on an appeal. It certainly sounds as though you are concerned that if you are open and transparent, it may assist the appeal.
I think that's reasonable. A reasonable assertion.
Yes.
Yep.
And do you think that that is not the best approach or best advice that you could have been giving at that time?
Again, I think that's right. I would ask you to remember that we're on the 4th of July, so literally only a few days into my involvement in the entire Post Office process, substantively, with quite limited information and effectively trying to preserve the position until I knew what I was doing. I think that's what it comes down to. But I accept that the commentary you pass on this is perfectly valid.
Could we please look at poll 00297-182? Same day, a bit later on, you respond, Simon Clarke, yourself to Roderick Williams, although
It's not up.
it's forwarded, yes, it's poll 00297-182. I think maybe you wrongly or inadvertently sent it to Martin Smith first, or it's certainly forwarded to Roderick Williams, and it's to Roderick. Perhaps you thought Martin Smith was going to forward it. Are you able to assist us at all?
Looking at this, it's likely that I forward it to Martin Smith for him to pass on. Again, This was very, very early on in my dealings with Roderick Williams, and so it's likely I would have thought it had better gone through Martin to Roderick than through me direct, but that's just a silly protocol thing.
If we scroll down, it says as follows, Roderick, what we had initially believed to be perhaps one of the more difficult cases, in fact, turns out to be one of the easiest. This defendant is awaiting his trial and accordingly has not been convicted and sentenced. Because we are now just pausing there, so it seems as though it's not an appeal case that you were concerned about because they haven't yet been convicted.
I think that must be right.
Yes.
And can I add this? This also looks like it's a case being prosecuted not by Post Office, but by the Crown Prosecution Service.
Yes, and in light of that, your advice is as follows. Because we are not the prosecutor, our duty extends to the following. 1, identify the name of the defendant. 2, identify the prosecuting CPS area. 3, inform the CPS area of the existence of B14, that it has affected that branch, and that a report is due soon. 4, disclose the second site report to the CPS once we have it. If we follow this route, the disclosure ball will be in the CPS court and our duty is satisfied. Just pausing there, is that right? I mean, you had more information than just the existence of B14 and the fact that the second site report was going to be published. You had that transcript of the conversation with Gareth Jenkins. You had your knowledge about Gareth Jenkins having been involved and about his reliability. You had the various other discussions. I don't know if by this point you had the Helen Rose report or not, but you certainly had more information than is being suggested be disclosed. Are you still confident that that was the right advice to have been giving?
It's right as far as it goes. That is, the duty is to disclose to the CPS so that the CPS then take over responsibility for the general disclosure function. But I agree with you that there should have been more.
You say they will know the defence being run, and if the defence is based on the proposition that Horizon may be responsible or that it is implicit in the defence per Samra, then they will disclose. If not, they will not. I think contact with the CPS should be made by us at this end so as to maintain a firewall between the Post Office and this overall problem, so that you are seen to be acting independently and transparently through lawyers, and because we are in any event dealing with the other reviews. Can we please move on to poll 001452201? And if we could start on page 2, just this is going to assist us with the timing of various things. If we see there the 4th of July, Hugh Flemington is sending you a first rough draft from Second Sight of one half of the interim report. That is a significant part of that report that details the 2 bugs.
Yeah.
If we go on to page 1, Martin Smith sends an email at the bottom of this page saying our advice overall with regard to disclosure has not changed. The disclosure of a partial report would not meet with our duties or help the current situation. I think the disclosure of a partial report would provide partial information and give rise to adverse publicity and speculation. It would be far better to advise once we have seen the entire report. Having said that, the second site report would not need to be disclosed in every case. That decision would be taken on a case-by-case basis. In many cases, it will not be disclosable. He says our overall advice. Is it fair to suggest that you inputted into this?
Yep.
To what extent was it his advice? To what extent was it your advice? Whose typing was this, for example? Do you think you sent it?
It's got my style about it.
Yes.
I can't say I wrote it, but it looks as though I've given some real input into it.
So we know that the second site report is almost complete. 5th of July, you are expressing concerns again about adverse publicity and speculation.
Yep, I agree.
Can we go to poll 00129740? Now, we're going to look at the draft letter to the Merthyr Diffen post office and the one that was ultimately sent. So there are, in fact, two documents that I'd like to bring up on screen side by side. This one is the draft letter that was sent to you, and we saw the covering email. And then I want to look at the final letter, and that is poll 00002213 at page 16. Thank you very much. If we could go back one page on the left-hand side. Thank you. So on the right-hand side, we have that earlier draft that you commented on. On the left-hand side, we have the final version, which was sent on the 5th of July, so the day after that first draft second site report. If we could look at the whole of the document on the left-hand side, please. Thank you very much. Let's keep them side by side and focusing on the right-hand side, first paragraph. It says, as a result of central data reviews in the Post Office Finance Service Centre, we have identified a small number of branches whereby a system error in data archiving processes has led to an error in the calculation of losses and gains at branch level. Just pausing there, is that right? Are you aware that the basis for that finding, that particular bug, was a result of central data reviews in the Post Office Financial Service Centre?
No, as I understood it, the bug was informed by Gareth Jenkins stroke Fujitsu's second site.
It then says your branch is one of the small number affected, and we can see on the left-hand side that sentence, your branch is one of the small number affected, has been removed in the final draft. Do you see that?
I see that.
It then says we apologise for any confusion this matter may have caused, and we want to assure that we have subsequently worked with our suppliers to understand the root cause of the issue and take action to resolve it. You may, however, not have been aware of this matter at the time, but we nevertheless felt it important to make you aware of this incident and its resolution. The purpose of this letter is to summarise the outcomes of this review and to confirm the remaining steps which we will be taking to conclude this incident. Those two paragraphs are the same in both. Mm-hmm. But then it's the next paragraph on the right-hand side. The occurrence of this amount as a discrepancy has been confirmed as relating to a specific and unusual set of circumstances which are not due to any mistake by yourself. So the suggestion, the clear statement there from the post office that it wasn't the sub-postmaster's fault, that doesn't seem to have made it into the final version. And then if we scroll over, both pages, please. In fact, on the left-hand side, if we could stay with the first, it may assist. That top paragraph on the right-hand side, this has impacted only 14 branches, and we are issuing similar correspondence to all parties concerned to confirm that the issue is understood and that proper remedial action has been taken. That doesn't appear in the final letter either. Can you see that?
I've not... Oh, I see, yes. Yep, I see that.
Yes. Now, we saw your advice earlier was a concern about notifying the branches that there were other branches and the publicity that that might generate. Do you recall seeing that advice? It looks very much as though that advice was adopted by the Post Office, who then removed any mention to the individual sub-postmaster that there were other branches that were affected.
It does.
Yes. What part of a criminal prosecutor's duty do you see it as to be concerned with adverse publicity?
None.
So the advice that you gave to the Post Office in respect of this letter, do you think that that was appropriate or inappropriate advice?
It was ill-judged and inappropriate.
I'd like to now move on to the
Before you do, Mr. Blake.
Yes.
In defence of the author of the final letter, if you look at the first paragraph, it does indicate in that more than one branch was affected, does it not?
It does, although it does remove...
It waters it down. Let's
Yes.
put it like that. Yeah?
Absolutely.
Fine, thanks.
Thank you. If we could take that down, please. Moving on to the general advice and SIFT, can we please look at poll 00006365? So we're now at the 8th of July, so we're a week after that public interest immunity hearing, and you have written your general advice about, if we scroll down, it begins addressing alternative Fujitsu expert and how Gareth Jenkins should be replaced. And we can see there at paragraph 221 that the second site report is about to come out. It's due to be published at 6 o'clock that evening.
Yeah, just in terms of chronology, I would ask you to recall that I'm still only 8 or 9 days into this process, and so it's still very much a learning curve for me.
If we turn to page 3, please, it is the subject of the start date for the review process. I'm going to read those 3 paragraphs. It says, a number of start dates are suggested. 12 months back from today, the date of separation of the Post Office from Royal Mail Group, the initial Horizon Online migration date, others. Considerations as to the selection of the start date include proportionality, resourcing, transparency, and Post Office reputation. I have come to the view that all of those considerations militate in favour of a date close to the initial Horizon Online migration date of 2010, perhaps using the 1st of January of that year. I arrive at this view not least because any sub-postmaster prosecuted prior to that date would have been prosecuted using original Horizon data. Any sentence of imprisonment, unpaid work or fine would by now have been completed, and the publicity which is bound to arise once Second Sight has published will place older defendants on notice. Just pausing there, you've said that you had only very recently got involved. Do you think that you were sufficiently informed by that stage to have been giving this advice?
Can I ask you, please, to take me to my statement paragraph where I deal with this? Because I thought very carefully about this and I want to confirm what I said to you.
Yes, please do let us know which paragraphs you're...
I'm struggling to find it, to be honest, but I did deal with it.
I mean, can you try your best without referring, because we have what's written in your statement.
Yeah.
It would be
Well,
best
Well,
to...
I stand by what I wrote in my statement. Somebody's put my statement up now.
Yes, but I don't intend to take you to any particular paragraphs.
No, can we go back to the document you were asking me about, please?
What I'd really like is just your reflections as to whether at the point you were writing this, you thought that you had sufficient knowledge about these cases to make such a significant judgment.
This is in relation to the start date?
Yes.
Yeah. I think I had sufficient knowledge to make the decision about the start date, because the most important factor in that respect was that we had been told that on the 1st of January 2010, the new online system had been rolled out, so to speak, and that every branch had been audited prior to that rollout to ensure that everything balanced properly. And so it was a good benchmark to say from this date there were no problems with Horizon and Post Office accounts, and so anything moving forward from that date could be inspected to see whether or not there was an issue with the bugs, etc. Prior to that, we were dealing, I think, with an old system.
That's paragraph 132 of your witness statement,
thank
and
you.
that's exactly what you've said.
Thank you.
It's difficult to understand why an audit at the end of Legacy Horizon, beginning of Horizon Online, would make a difference in terms of that date. Can you elaborate on that?
Oh yeah, because on the date the audit was done, you knew that there were no discrepancies in the accounts. You knew that there were no questions about whether or not the relevant sub-postmaster had fallen into error or made mistakes or even had committed offences. It was a very clean start point.
But what if you had been prosecuted before the change to Horizon Online, had stopped becoming a postmaster, were in prison, may have had your life ruined, your children's lives ruined? How would the audit at the end there have assisted at all with knowing whether they were fairly prosecuted?
It wouldn't have done, but our understanding at the time that this decision was made was that the two bugs that we had been told about affected the Horizon Online system, which only started after the 1st of January.
But you also knew at that time that Gareth Jenkins was an unreliable witness.
We did.
Who had given unreliable evidence.
We did.
And you knew that a system such as Horizon could be capable of having additional bugs.
Old Horizon as well, yes, we did.
Yes. So with that in mind, it may seem to some, although we know that Mr. Altman agreed with you, that date was chosen given that people had been prosecuted for a number of years before, some, including Ms. Misra's case, although that was ultimately looked at, involving Gareth Jenkins.
Well, there are two parts to my answer to that question, I think. The first is that we had to choose a date. It seemed at the time that, for the reasons I've given, it was the most logical date to choose. But we then learned very quickly after that Brian Altman had been instructed to supervise us. So the word supervise was used, to supervise us. And one of the things he did was he looked at the start date, considered the rationale behind it, and agreed with it. And had he said, I don't agree with that start date, we should go back further, I don't want to push responsibility onto somebody else because I stand by the decision I made.
I mean, he was reviewing the advice that you had already given.
Forgive me. We had given the advice that the start date should be the 1st of January. Brian Altman reviewed it and said, I agree with the reason, whatever language he used, I agree with the start date chosen by Mr. Clarke. That vindicated my decision. If he had said, no, I think you should go back 10, 15, 20 years, I have no doubt that that's what we would have done.
If we look at this now, though, the very first phone call you had with Gareth Jenkins, he said he can't rule out there being other problems, which made a lot of sense to you. Second Sight interim report had identified 2 bugs impacting 76 branches, admittedly involving Horizon Online. Helen Rowe's report, it's not clear yet whether you've read it by this date or not, but that also raised issues of Horizon integrity issues. Did this not all cause you to think that there might be some issues with what we know as Legacy Horizon?
It didn't at the time. I rather suspect largely because we had followed the route that the 1st of January 2010 was the appropriate start date. And if you want to suggest that, in a sense, that put blinkers on us going forward, then I think that would probably be correct.
Yes, because all prior assurances you had received had proved to be wrong.
Yeah.
Did you at any stage, other than today, look at it and advise that actually we might want to rethink the start date?
Yes, over the SIFT process, it became clear that, to us, perhaps we were rather dim about it, but it became clear to us that the issues with Horizon extended back before the 1st of January 2010, and we started receiving cases for review that went back before that. I'm not convinced we received every case that had been prosecuted, but we did expand the ambit of the Horizon, the pre-1st of January review, but I can't say when that took place. And I think in the end, we reviewed something like, I've got a figure of either 400 or 700 cases, but we reviewed a lot of cases, and some of those would have been pre-January 2010, so we did go back after a time.
But not a comprehensive look.
No, I don't think that was. No, I think you're right.
And considerations such as the fact that a sentence of imprisonment or unpaid work or fine would now have been completed, and therefore you shouldn't look at them. Do you look back at that and think that wasn't the best advice?
Yeah, I think probably I do.
A separate criticism of the review is, that can come down, thank you, regarding independence and an alleged lack of independence. What do you say about that?
Generally or specifically? In general terms, I don't think there was any real issue of conflict in the review.
I mean, who was carrying out the review?
Well, there were two aspects to it. The first aspect was that every case has to be sifted to determine whether or not Horizon figured in the prosecution evidence. If Horizon didn't figure in the prosecution evidence, and an example would be there was a case where an SPR MR was taking money from the post office and loaning it to family members, that's clearly not a Horizon case, then they were put to one side. If it was flagged up, and the threshold I think was quite low, if it was flagged up as a Horizon issue case, then it was reviewed by either me, Harry Bowyer, and we had 3 or 4 external counsel that were instructed on an ad hoc basis to come in and conduct reviews as well.
Would you be surprised if I said that you and Harry Bowyer, in terms of the sifts, reviewed 76 of 81 sifts?
Not at all.
You reviewing 33, him 43?
Not at all.
In those circumstances, do you think it can fairly be characterised as a review that's being carried out by an independent firm?
Yes.
But that's the same firm that had been prosecuting on behalf of the post office. Do you think it can fairly be described, even if you say, yes, I looked at this and I was personally independently minded, do you think it can fairly be characterised as a review being carried out by an independent firm?
I can see why people might think otherwise. For my own part, at the time, I didn't, but I accept that there is a view which goes, yes, it actually probably wasn't as independent as it ought to have been.
I'm going to move on now to the Gareth Jenkins advice.
I would also accept, forgive me for interrupting you, I would also accept, now that you've given me the numbers, that there might also have been a degree of becoming case hardened by reviewing so many cases. I accept that's a possibility as well.
What do you mean by that?
Well, when you review case 1, you are absolutely fresh at it and much more vigorous, I would expect. By the time you get to case 35, it's inevitable. Human nature tends to dictate that you've seen it all before, and perhaps you become slightly more, cynical about what you're doing. I accept that. I think that's an appropriate comment to make.
I mean, it might be suggested that in carrying out those sifts, you should have spotted trends and themes that were arising.
Yeah, I accept that.
Yes. And is that also, you think, down to becoming immune or case hardened?
That's exactly what I'm referring to.
Yes.
That's the point I'm making, that because you become slightly cynical, jaded, as inevitably is going to be the case, then you do miss things. Yes, I accept that.
Moving on to the Gareth Jenkins advice, can we please look at poll 0029767? This is before I come on to your formal written advice. which was the 15th of July.
Yeah.
We're going to start on the 10th of July 2013. And the bottom email is an email from Roderick Williams to yourself. He says, Martin, Simon, do you have some suggested wording for how we break the Gareth Jenkins news to Fujitsu, including why it is a problem for you from a criminal law perspective?
Yep.
Can you assist us with what's meant there, breaking the news to Fujitsu?
Well, they had to be told that their expert had misconducted himself.
And if we scroll up,
Because they would be asking the obvious question, why aren't you using him anymore?
Mr. Smith responds, Simon is preparing a further advice about Gareth Jenkins, and that's, I think, the one we'll come to. However, he touched on the Gareth Jenkins point in his advice of the 8th, and that I think we saw as well, the beginning paragraphs. If we could look at poll 001919666, please. There's an email from Roderick Williams to Andy Parsons. Andy, as discussed, please see the attached, which sets out the high-level issue with which Cartwright King, our criminal law solicitors, has identified with the Fujitsu evidence Gareth Jenkins has been providing in support of the criminal prosecution cases conducted for Post Office Limited. A more detailed note should arrive on Monday, which I will forward you once I have it. Can you please consider this in light of the contractual arrangements we have with Fujitsu and draft a suitable email to Fujitsu to put it on notice of the issue? That's Roderick Williams to Andrew Parsons, copying in a number of other individuals. And can we please look at the bullet points that were attached to that? They can be found at poll 001919667. Now, these are quite brief, these bullet points.
Yeah.
Let's read them. Fujitsu and Gareth Jenkins have for some time been providing the Post Office with expert witness statements and expert evidence for criminal prosecutions. A full report which considers Fujitsu and Gareth Jenkins' provision of expert evidence is being prepared. The initial view seems to be that statements and evidence provided by Gareth Jenkins did not contain all that they should have done. In particular, there seems to have been a reluctance to deal with known horizon issues in the statement/evidence. As a consequence, it has been necessary to conduct a review of cases so as to determine whether or not any particular defendant has been prejudiced by the absence of information. Do you think that that's underplaying the issue somewhat?
No, I hadn't conducted my review then. I think I'm preparing them for what's coming.
I mean, the conversation that you had with Gareth Jenkins, you described, or I described as a bombshell, and you agreed with that. I think you expressed to me serious concerns from that conversation and from the information you'd received the day before. Do you think that a reluctance to deal with known horizon issues is an accurate reflection of the strength of your feelings?
I think there's a difference between having serious concerns, which I had and which I told you about, and condemning a man before I'd completed my report is quite important. What I didn't want to do is point the finger at Gareth Jenkins in writing and say, you have misled the court, until I was certain of my position.
And then we have your advice. That can be found at poll 00006357, please. And that's the 15th of July. Were you ever involved in the instruction of Gareth Jenkins?
No.
Prior to this issue having arisen, had he ever been a topic of conversation within the office at all with your colleagues?
Not that I'm aware of. You've got to, again, remember that, were you aware that Cartwright King operated from a number of different offices.
Yes.
And until I was instructed, and even during the course of the Samra case, I was based in the Nottingham office, and the Post Office Department, I think, was based in across Derby and Leicester. So I wouldn't have been a party to any conversations prior to the Samra case in any event. During the course of, it was during the Samra case that this arose, and then, yes, of course, he then became pretty much the central topic of discussion.
But prior to the research that you carried out for this advice, were you aware, or did you have any knowledge about the basis on which Gareth Jenkins had been instructed?
No, didn't even know of the existence of the man.
And you had that conversation on the 28th.
Yep.
Before that conversation, were you aware of how he had been put forward as a witness in those proceedings?
No, not at all.
Would you have expected those at Cartwright King who were involved in his cases to have known about how to properly instruct him?
Yes.
Martin Smith's evidence was that he wasn't aware of the legal requirements. Were you surprised by that?
When I saw him say that the other day, I was surprised, yes.
Had you understood his knowledge at the time to be sufficient to have that kind of knowledge?
I think assumed is a better word. I had assumed at the time that things had been done properly, yes.
One thing that you point to in your witness statement was that Gareth Jenkins had signed off his witness statements that he understood his role was to assist the court.
Yep.
Did you, at that point on reading those statements, question why he didn't have the usual expert declaration within those statements?
No, because I wasn't at that point concerned with whether or not he'd been instructed properly. That was, I was interested in effect, not cause. Effect was he had failed to tell the court that which he ought to have told them, both in his witness statements and orally in the Seema Misra case. That's what I was concerned with. So I didn't look to see whether he had been instructed properly in the first place, because that's in the past, and that was of no concern to me. My concern was he hasn't told the court what he ought to have told them. How do I deal with that?
Can we please look at page 14? We've seen this advice. I'm not going to take you through every paragraph
I wrote it.
of the advice.
Yeah.
The chair has it. If we could look at page 14, there are some conclusions. If we could scroll up, please. It says, notwithstanding the failure is that of, and it's Gareth Jenkins, and arguably of Fujitsu Services Limited being his employer, this failure has a profound effect upon the Post Office and the Post Office prosecutions, not least because, by reason of Gareth Jenkins's failure, material which should have been disclosed to defendants was not disclosed, thereby placing the Post Office in breach of their duty as a prosecutor. Very strong words there.
I don't know where I get doctor from, but yes, very strong words.
By reason of that failure to disclose, there are a number of now convicted defendants to whom the existence of bugs should have been disclosed but was not. Those defendants remain entitled to have disclosure of that material, notwithstanding their now convicted status. As you say, powerful stuff. Are you aware of who this advice was shared with within the Post Office?
I can't remember how it got to Post Office. I don't know whether I sent it or whether I gave it to Martin to forward to Jarnell. To my direct knowledge, Jarnell Singh had it and Roderick Williams had it. Where it went thereafter, I can't say. I would add, with hindsight, which I've already said in my statement as a cruel master, but with hindsight, I now know that a number of the advices I wrote did not go where they ought to have gone, even though I had expected that they would.
Even if you're not aware of where that actual written document went, are you aware of any other names within the Post Office who you are aware received the substance of your advice?
No. I can't say who did and who didn't see it, or who did or who didn't receive the import of the advice.
I'm going to move on to the Criminal Cases Review Commission, can we please look at poll 00039994? This is a letter you'll have seen me take Mr. Smith to.
Yeah.
It's a letter from the CCRC to Paul of Ennals, 12th of July 2013. If we scroll down, we can see it's after the publication of the second site report, and they say, for obvious reasons, we have read the recent media coverage concerning the Post Office Horizon computer system with interest, and they would like more information. Could we look at poll 00039998, please? Top email says, please find attached documents prepared by Simon in response to that letter. So it seems as though you have received a copy of that letter and drafted two documents. One is a draft response and another is another document that I'll take you to first. That is poll 00039993. Thank you. What was the purpose of this document?
I think they asked me what the ambit of or scope of the role of the CCRC was, and I think here I summarise as best I can in fairly plain language, layman's language,
And
what
there
the role
are
of the Commission was.
two criteria that are applied. The first being that they had tried to appeal.
Yep.
The second, there must also be some important new evidence or legal argument available to the defendant, for which see below. And if we scroll down, we can see a comment by you. As to the second site interim report would fall within the scope of that criterion on the basis that it was important information not known at the time of the original trial and which has emerged since conviction. It seems as though, as at the 16th of July 2013, it was pretty clear to you that the second site interim report fell within that second limb of important new evidence.
That must be right, mustn't it? Not that it was clear to me, but it fell within that category. Yes, I agree.
Can we please look at poll 00039993? This is the draft reply. Sorry, it's 3995. If we scroll down, thank you, you say there at that bottom paragraph, where a defendant asserts, rightly or wrongly, that Horizon is at fault, it is for the prosecution to demonstrate the integrity of the system and the evidential audit trail derived from Horizon. Now, were you aware, anecdotally at least, from those who were involved in those prosecutions, that in reality the burden was largely put on defendants themselves?
I became aware of that after my involvement in Post Office, yes.
When you say after your involvement?
Well, I didn't know before May 2013 because I had nothing to do with it, Post Office.
At the time of writing this, in July 2013, were you aware that that was the case, having presumably already been sifting a number of files?
Early on in the sift, I don't think I formed that view later. I don't think I'd fully formed that view then, but I think it's fair to say that there were indications emerging that those who were prosecuting were not doing that which they should have done.
We then move on to Gareth Jenkins. It says, this is usually accomplished by the serving of expert evidence. For many years, both the Royal Mail Group and latterly the Post Office has relied upon a single expert witness provided by Fujitsu, the Horizon manufacturer, maintenance and support contractor. That witness has provided expert evidence in many cases where the defendant has asserted irregularities with Horizon to be the cause of unexplained shortfalls as the operation and integrity of the Horizon system. He has done so both to the Post Office and in expert witness statements and oral evidence to the court. In particular, he has attested to the presence of defect detection and rectification systems, the robustness of the prosecution audit trail, and stated that in his expert opinion, Horizon accurately records and processes all information submitted into the system. The second site interim report demonstrates that this was not the case. You knew by the point at which you were drafting this letter that Mr. Jenkins wasn't to be relied upon because, as you've explained, he was the very source of those bugs that were disclosed to second site.
Yes, I agree.
Why do you think that wasn't set out in this letter?
What, that I knew?
That there was a real concern, not simply that there was new information that had appeared, but that the very expert that had been instructed in prosecutions was, in your view, by that stage, unreliable.
Well, I think this letter does say that.
If it does that in a very subtle or unclear way, in fact, doesn't it? I mean, it doesn't raise there any real concerns about the integrity of Gareth Jenkins.
I'm going to have to disagree with you. I think that last paragraph you read does precisely that.
I mean, you had written the very day before, the 15th of July,
Yep.
a very significant piece of advice with very strong words. I took you to those last two conclusions, placing the Post Office in breach of their duty as prosecutor, etc. Do you think that the sentence, the paragraph that I've just taken you to, do you think that accurately reflects the strength of your advice to the Post Office?
That's a different question, isn't it? The question you were asking me, forgive me, I don't want to be rude.
Yes.
The question you were asking me was whether or not I was advising in terms that they be told, that the CCRC be told about Gareth Jenkins. And the answer to that question is they are here. I agree with you that I don't say it in such trenchant terms that I do in my written advice to Post Office.
It is a particularly tepid response to the CCRC in circumstances where you had real concerns about the reliability of Mr. Jenkins, isn't it?
I don't agree with your choice of words.
Do you think it is reflective of the advice that you gave to the Post Office?
It tells the CCRC that the expert that has been relied upon has not done that which he ought to have done.
It suggests that the second site interim report, which has been published after the expert has given evidence, prosecutions have concluded, has proved that information that he had provided is now no longer the case. But it doesn't raise any concerns about the actual information that he was giving to the courts.
I think that's read into that paragraph. We can get bogged down by this.
I mean, let's have a look at the if we could zoom out perhaps and just look from the words "where a defendant" down to "this was not the case." Where do you say that was reflected in this paragraph?
For many years, RMG and Lassie Poll have relied on a single expert witness, and then it goes on to say what the expert witness says. That witness has provided expert evidence in many cases where the defendant has asserted irregularities. He has done so both to Poll and in expert witness statements and oral evidence to the court. In particular, he has attested to the presence of defect detection and rectification systems, the robustness of the prosecution audit trail, and stated that in his expert opinion, Horizon accurately records the processes of all information submitted into the system. That is setting out what the expert has said in his reports. The following sentence, the second site interim report demonstrates this was not the case, very clearly, in my view, says that that gives the lie to what's been said in the preceding paragraph.
And does it say he knew it at the time?
No, it doesn't.
And why doesn't it?
I thought that was sufficient.
Do you think that that conveyed your opinion that he knew it at the time?
Yes.
I mean, looking back at it, do you stand by that?
Yes.
If we scroll down, please, page 2. To that end, the Post Office has instructed an independent firm of criminal specialist solicitors to identify every criminal case prosecuted by the Post Office and Royal Mail Group prior to their separation. That's the point I was asking you about before. Do you think that that is a fair description of the role of Cartwright King, or do you think that that is somewhat putting a gloss on Cartwright King?
Well, I think I'd already answered that question, and you know my view now. At the time I thought it was right, my view now is perhaps not.
Was it intentionally drafted that way to give the appearance that it was something that it wasn't?
No. I've just told you that at the time I thought it was the correct view.
If we could go over the page, please, to page 3. If we scroll down, please. It says, where counsel has advised the possibility of grounds of appeal, letters have been written to solicitors who defended, informing them of the issues and providing copies of the Second Sight interim report and such other material as they ought to have received during the currency of the prosecution, had we then been possessed of that material. It would then be for a defendant and his lawyers to determine whether or not they wished to launch an application for leave to appeal out of time. We would certainly support grounds to allow the application out of time. So reference there to the Second Sight report and such other materials. I think actually that phrase is lifted from Brian Altman, or it certainly appears in Brian Altman's interim review. I don't know if you recall taking it.
It's entirely possible.
We still there don't have any mention beyond Second Sight of, for example, the Helen Rose report. We don't have any mention of any other information, the kind of information that was very clearly apparent to you from that Gareth Jenkins conversation on the 28th. Do you think that that is sufficient information that was being provided at that stage?
Well, the only information we had was the Second Sight report, the fact that it was Gareth Jenkins who had informed Second Sight of the existence of the bugs, and the Lepton report. That I think was the extent of that which we had.
And is the Helen Rose report mentioned there?
No, it's not.
No. Are the concerns that were immediately apparent to you, the bombshell conversation from the 28th of June, is that reflected there at all?
I think it's a more measured response.
A more measured response, or a carefully worded response to make it seem as though there wasn't very much material to be handing over?
Two answers. Yes, it was carefully worded. Everything I write, I try to word as carefully as I can. But no, it was not carefully worded in order to minimise.
Could we please turn to poll 00192214, bottom of page 3. Susan Crichton has received your draft letter, and she says to Andrew Parsons, Andy, we received a letter from the CCRC yesterday, which I've asked Cartwright King to review. Their advice feels odd to me, as if given on a take it or leave it basis, and I'm not comfortable that's particularly useful in this context. Could we discuss? I'm happy to go to another firm that specialises in criminal law or a barrister. Somehow it feels as if there's a conflict here, which I am not sure I understand. Were you aware that the Post Office had concerns about the strength of your response or the content of your response?
No.
Looking at that now and the discussion we've just had, do you think actually, looking back at that draft, it was too... I was going to use the word robust. I won't necessarily use the word robust, but it was too punchy.
What, my draft response?
Yes.
That it was too punchy?
That it was limited in the information that it provided, justifying the work that Cartwright King was carrying out, and was not an open, transparent and fair response to the CCRC's request for information.
No, I don't agree with that.
And did anybody at the Post Office ever raise with you concerns in respect of that letter?
They didn't, but I read this email as Post Office taking the view that it was too strong. This looks to me as though they're suggesting that they might want to water it down. I speculate.
When you say water it down, what do you mean by that?
Well, they clearly didn't like what I'd written. Looking back from what I know now, and from what I've heard during these proceedings, it rather looks to me as though they were thinking I was going too far.
Providing too much information?
Yes. But that's me speculating.
Thank you, sir. I think that's an appropriate moment to take our second mid-morning break. Perhaps we could come back at 12:10. I think you're on mute, sir. Sorry, sir, we can't hear you.
Yeah, sorry. Unless it interferes with your train of questioning, in which case I don't need to know the answer to this question now. But what in fact happened to that draft? Was it sent in that form or not?
I don't think we have a final letter. Certainly there was not a letter sent for a very long period after that.
Right, fine, thank you. Do you need an extra minute now, Mr. Baker,
No,
after my intervention?
12:10 will be fine. Thank you,
Right.
sir. Thank you, sir. For your benefit, there is correspondence with the CCRC at poll 000400190. I won't bring it up on screen, and so we can look at that in longer time.
Fine.
As to whether it's a holding response or something more substantive.
Yeah, sure.
Also, Mr. Clarke, you asked about the Helen Rose report and whether that was mentioned in your advice of the 15th of July 2013. It was mentioned. It's at paragraph 26 of that advice.
Fine. So I got it before then. Yeah, that's fine. Thank you.
I'm going to move on now to your document retention, or what's been referred to as the shredding advice.
Oh, yeah.
You had advised a central hub to be created.
Yes.
Was it your understanding that all Horizon-related, for example, bugs, errors and defects, and remedies would be kept in that hub?
Was my understanding. I wrote a protocol which required that.
And participants could bring to those meetings any concerns about Horizon, however critical they were of the Horizon system.
I repeat, that was a requirement of the process, and it appears in the document, the protocol that I wrote, which was to apply to these meetings.
Minutes were to be kept,
Yes.
minutes were to be disseminated.
Yes.
Was it your understanding, save for the fact that it was written down in a protocol, that it would in fact happen?
That was the point of the protocol. I required it, in so much as I could as an advising barrister, I required it to happen.
And from conversations you had at the time, was it your understanding that it would happen?
Post Office appeared to me to have accepted the advice and protocol wholesale.
Thank you. I'm going to go through chronologically the issue with John Scott and the conversation with John Scott. That's poll 001-39745. It's a document I took Mr. Smith to, and that just sets the scene. 31st of July 2013. We have that conversation between Jarnail Singh and Mr. Smith.
Oh, yeah.
And the summary there is discussing disclosure issues. John Scott has instructed that type minutes be scrapped. And then we move on, poll 001-39746. Jarnail Singh emails Mr. Smith the same day, and he says, I know Simon is advising on disclosure. As discussed, can he look into the common myth that emails, written communications, etc., meetings, if it's not produced, it's then available for disclosure. If it's not, then technically it isn't. Possibly true of civil cases, not criminal cases. Is this, you're not a named recipient there, is this an email that you saw or that was conveyed to you at the time?
No, the first time I saw this email, I think, was during these proceedings when it was sent to me.
Did you understand that Mr. Singh had requested advice of that nature?
No.
He says there, I know Simon is advising on disclosure. What was your understanding as at the 1st of August as to any request for advice on disclosure. Was it the shredding advice that we see, or was it something else?
It wasn't the shredding advice. It was the... I presume it's a reference to the advice I'd done earlier on about setting up the hub and Post Office's general disclosure duties. I presume that's what he was referring to.
Thank you. Can we move on then to poll 00006799, and that is the advice on disclosure, the duty to record and retain material. That's written by yourself on the 2nd of August 2013.
It was.
You've addressed it at paragraph 47 of your statement and also at 93 to 95 of your statement. I don't need to take you to those. We can have a look at the advice itself, page 2. Paragraph 5, please. So you say there you're describing, summarising your state of knowledge at that time. And you say at some point following the conclusion of the 3rd conference call, which I understand to have taken place on the morning of Wednesday, the 31st of July, it became unclear as to whether and to what extent material was either being retained centrally or disseminated. The following information has been relayed to me. Number 1, the minutes of a previous conference call had been typed and emailed to a number of persons, and instruction was then given to those emails and minutes that those emails and minutes should be and have been destroyed. The word shredded was conveyed to me. Now, can you assist us with where that came from? And the words shredded, who was it that conveyed those words to you?
That came from Martin Smith. I remember particularly because I was going on holiday. That was the day up my leave was to start. And I postponed my departure upon receiving that information from Martin Smith because I took the view that that was just too serious to ignore.
Martin Smith said he couldn't quite remember the exact words used. The fact that you've used that in speech marks, does that imply that it was in fact the word that was used by
I'm certain that that is the word that was conveyed to me, and the reason I'm certain is because this was written 1st/2nd of August, and it was 1st/2nd of August that I would have received this instruction, and so it would have been fresh in my mind. This, in effect, is a record of the conversation I had with Martin Smith.
Thank you. Mr. Singh said that those were John Scott's instructions. To your understanding and from what you were told at that time, was John Scott seen as a lone wolf or someone who was working with others in that respect?
The impression I got from within Post Office and within Cartwright King that he was regarded as being a bit of a power unto himself, which is effectively the same as what you've just suggested, I think.
Number 2, handwritten minutes were not to be typed and should be forwarded to Post Office Head of Security. I think you've said in your statement that Jarnail Singh said that that was John Scott who had conveyed that. Is that second-hand through Mr. Smith?
So I'm thinking of the... Yes, it's second-hand through Mr. Smith.
3rd, advice had been given to the Post Office, which you report has relayed to you verbatim. If it's not minuted, it's not in the public domain and therefore not disclosable. If it's produced, it's available for disclosure. If not minuted, then technically it's not. I think you say in your statement that Jarnail Singh said that that was Mr. Parsons. Again, is it Mr. Smith telling you that he had been told by Jarnail Singh, or is that direct from Mr. Smith?
I would have... I'm frowning because I'm thinking of the shorthand writer who's told me off already. That was from Mr. Smith. All of those instructions came from Mr. Smith, but I've got a scratchy memory that I might have telephoned Jarnail Singh to confirm. I can see myself in the Nottingham office on the telephone, and I've just got that scratchy recollection that I might have telephoned Jarnail Singh to confirm these instructions.
And then 4, some at the Post Office do not wish to minute the weekly conference calls. In your statement, I think you've said that those were Jarnail Singh's own views. Is that right?
That tends to suggest that my scratchy memory is correct, that I had a brief telephone call with him to confirm the instructions. But certainly that was the information I received, yes.
Who did you understand to be the sum at the post office?
I don't think anybody identified who the some were, but given that it was John Scott who gave the instruction to shred, looking back, I suspect I was thinking at least in part of John Scott.
Thank you.
To suggest anybody else would be speculation.
Could we please turn to page 5 and paragraph 9? The duty to record and retain material cannot be abrogated. To do so would amount to a breach of the law and, in the case of solicitors and counsel, serious breaches of their respective codes of conduct. Accordingly, no solicitor, no firm of solicitors, and no barrister may be a party to a breach of the duty to record and retain. And neither may they act in circumstances where they are aware or become aware that a practice has developed within the investigative or prosecutorial function such that the duty to record and retain is being deliberately flouted or avoided. Again, to do so would amount to breaches of both the law and codes of conduct. A decision-based failure to record and retain material would readily amount to such a practice. Such a decision, where it is taken partly or wholly in order to avoid future disclosure obligations, may well amount to a conspiracy to pervert the course of justice on the part of those both taking such a decision and those who implement such a decision, where they do so in the knowledge that it was taken partly or wholly for that purpose. Again, very strong words used by you in that advice. Do you agree with the advice that you have given here?
Yes, of course.
Next paragraph, paragraph 10. In view of the matters referred to in the previous paragraph, where were the issue of disclosure to be raised in court in circumstances where an investigator or post office officer, employee suggested that advice different from that contained within this document had been given, such would amount to a waiver of legal professional privilege so that the document would itself become admissible in proceedings. What was your concern here?
Andrew Parsons' advice, I think, because it was Andrew Parsons who gave that ludicrous advice about if it's not written down, it's not disclosable. I think that was directed to him as a warning of the path he was apparently contemplating.
I suppose this all raises the question of why wasn't this the very last piece of work that you ever carried out for the post office? Because
my understanding was this was not a post office policy or instruction. This was John Scott on a frolic of his own. And forgive me for interrupting you. And I saw it as my function to bring it to the attention of post office in a formal advice document so that they could then take the necessary steps to make sure that the policy that he seemed to be advocating was not put in place. And I rather saw my role as telling post office what one of their staff was contemplating and for them to take the appropriate action to deal with it. And I understand that they did. I know it sat in a drawer for a couple of weeks, but they did.
You've explained that you were pretty new to post office prosecutions in the summer of 2013.
Yes.
You've had this bombshell from Gareth Jenkins. You've found out about bugs in Horizon that were said not to have been there. You've had concerns about the reliability of evidence given in previous prosecutions. You have the Helen Rose report. And now you're being told that even in the discussion of these issues, there is a shredding taking place in relation to the minutes of those meetings that you had personally advised should be recorded.
Yeah.
Did that not raise for you an issue of whether you should still be acting for the post office?
No.
Why not?
For the reason I've just explained. On the shredding point, I took the view, and I think the view was confirmed, that it was John Scott on a frolic of his own. In terms of the earlier material, I saw my function as being one to advise Post Office as to how they ought to remedy the situation they had got themselves into, and help them find a way through it. I don't think I was... If the real question is, did I consider that I was in conflict, or that a conflict existed such that I ought to have withdrawn? No, I didn't.
Not so much a conflict, but certainly what might seem a maddening situation by that time, that everything that you had been told about the reliability of the system was in question, and now you're being told about shredding.
I'm just a bit old-fashioned about this. Barristers don't walk away from their clients when life gets difficult. I saw my role as to be their barrister through Cartwright King, and to give them palatable or unpalatable advice, whichever, in the hope that I could do some... It's trite, but in the hope that I could do some good for them. I don't walk away from clients because life gets difficult. I didn't then, and I don't now.
You wrote this advice. Who did you expect to have seen the advice?
In a word, everybody.
Did you yourself follow up to ensure that it had been seen by...
I did. I think I told you I was just about to go on leave the day I wrote it. I did. When I came back, I think I went to Gibraltar, which is home. When I came back, about 2 weeks later, I asked Martin what had resulted. Had we heard anything back? What was the effect? And he said he hadn't heard anything, and I think he contacted John Elsing to find out what the position was. There's a vague recollection, but I think that's how we learned that it had sat in a drawer for a couple of weeks rather than gone to the people it ought to have gone to. I think I'd deal with that in my witness statement.
So we have the covering letter at poll 00282982236, sent by Mr. Cash for the attention of Susan Crichton and Hugh Flemington only. Would it have been unusual for Mr. Cash to have been taking the lead on this?
Can I just read it? Sorry.
Absolutely.
It would have been unusual for him to get involved, but recalling the immediate prelude to writing the advice, I was in the Nottingham office at the time, effectively saying my goodbyes. Martin was there as well. And I think Stephen Gelsthorpe, who was the senior equity partner, overheard what Martin was telling me. And I think Stephen Gelsthorpe suggested that the advice be, now that you've reminded me of this, that the advice be sent by Andy Cash, because he was the senior lead at Cartwright King for Post Office. So I think that's how that came about.
So was it intentionally sent by somebody senior to give the impression that it was a significant piece?
I see. I can't say. I wrote the advice, I gave it to Martin and said that has to go, and then I went on holiday. I wasn't a party to the decision that Andy Cash sent it, but I can quite see why it was chosen. He was chosen to be the sender.
It's marked there as for the attention of Susan Crichton and Hugh Flemington only. Had you selected those as the recipients?
No.
And what is your understanding of why they would have been the recipients rather than, for example, John Elsing?
I can only speculate, but Hugh Flemington was head of legal and Susan Crichton was general counsel. So it's going to the people who really ought to have seen it.
Thank you. Can we please turn to poll 00006797? And this was the response to Mr. Cash from Susan Crichton. I don't know if you saw the evidence of Susan Crichton.
No.
No, I took her to this document. If we scroll down, perhaps I'll read from the penultimate paragraph that says, Post Office Limited is committed to conducting its business in an open, transparent and lawful manner. Any suggestion to the contrary would not reflect Post Office Limited policy and would not be authorised or endorsed by Post Office Limited. Accordingly, the purported statements referred to in Simon's note do not reflect or represent Post Office Limited's position. The reference there to, first of all, I think you've said you didn't see this letter. Is that?
I don't think I did, no. I don't recognise it other than having seen it during these proceedings.
Was it communicated in some way to you that the Post Office had responded to
Yes.
your advice?
Yes.
What was said about the response?
That's why I set that inquiry in train when I returned from holiday. What came back was effectively this was John Scott on a frolic of his own, and it was not Post Office policy.
So if we scroll up, in fact, the point about it being Susan Crichton not having seen it, I think, she says, unfortunately, I had not seen your letter and was not aware of it until Martin's email on the 14th of August. So presumably the 14th of August was when you returned from holiday.
Yeah, and that's me asking Martin to chase it up, I would think.
And if we scroll down again, I mean, it's referred to in this letter as purported statements. From conversations that you had with Jarnail Singh, for example, was your understanding that they were purported statements or definitive?
They were definitive.
And were you aware of, outside of Jarnail Singh's knowledge, the knowledge of others within the Post Office, as the same, effectively?
No, the impression that Jarnail Singh conveyed to me, I think during that phone call I thought I'd had, was that this was John Scott doing what John Scott does.
Did Jarnail Singh seem concerned about it?
Yes. I think the proper word is frightened.
And was it your impression that it was going to go any further?
Sorry, in what?
That it was going to be taken further within the Post Office, or
What?
your advice?
Oh, yes. Well, that was it my impression? I expected it to be. I expected it to go to the very highest levels of Post Office and for them to deal with John Scott.
Could we please look at poll 00006485? This is a meeting of the 9th of September 2013 with Brian Altman, KC, Susan Crichton's there, Roderick Williams is there, Jarnail Singh is there, and yourself and the others from Cartwright King are in attendance. If we look at the final paragraph of that page, Roderick Williams then confirmed that the weekly hub meetings were starting to bed in, picking up any issues across the business which may relate to Horizon. Now, SC, it seems that is a reference to yourself. It's slightly confusing because both Susan Crichton and Simon Clarke are SC. Yeah. But if we scroll down, it looks as though it is you who said that there had been some cultural issues at the start, which had now been overcome, but you thought that it was necessary to put duties on individuals. Consequently, Cartwright King are in the process of writing a protocol to explain the purpose of the weekly hub meetings, the roles and responsibilities of individuals. Can you assist us with what you meant by cultural issues? Well, first of all, does this accurately reflect the conversation that you had at that meeting?
Well, I was going to say, I think that likely is me speaking. I think I don't recall the specifics of the meeting, but I think that it does certainly record my concerns. And so, yes, it's an accurate note.
And cultural issues, I mean, there's no reference there to shredding, destruction of documents. It doesn't look as serious as perhaps your advice was when it refers to cultural issues that had now been overcome.
Well, this is not my note of the meeting. I would not have said, oh, there's been a few cultural issues and moved on, not least because Brian Altman would have needed to know what the cultural issues were. And the cultural issues went beyond John Scott's shredding instruction. The distinct impression I got from the conduct of the early hub meetings was that most of the attendees from Post Office were quite reluctant to discuss and bring to the table what they knew. And I don't think culturally they understood that this had to be a complete, open and transparent forum Otherwise, there was no point in the exercise. I think that's what I meant by cultural issues generally. They had to understand that they had to be full and frank about what was going on at the meeting.
Were your real concerns about the destruction of documents discussed at that meeting?
I can't say. I don't recall. It's likely they were, but I'm not going to nail my colours to the mast on that. I can't say.
And it says that the cultural issues have now been overcome. How did you know that they had been overcome?
Martin would have reported back to me about the status of the meetings.
I mean, did you think that by the 9th of September all of those issues that you had raised in your advice had been overcome?
Well, that was the reports that I'd received. We'd dealt with the shredding issue, including the delay in post office higher echelons seeing it, and Martin was reporting that people were bringing things to the table, so to speak, at the weekly meetings.
That paragraph continues, the post office were picking up issues which were compiled
Sorry, I don't see that. Oh.
in the matrix, and it was observed that there had to be continuity of individual attendance at the meeting and everyone must be on message.
Yep.
Can you assist us with what's meant by continuity of individual attendance and everyone must be on message?
Yeah, when the meetings first started, attendees would change. I think the idea was that each department had an appointed representative at the meetings, and I think we noted that appointed representatives changed perhaps on a meeting-by-meeting basis, which we didn't want because that removed continuity. And so we wanted the message to go out. I'm not referring to being on message here. We wanted the message to go out that the same people must attend every time.
Thank you. I'm going to now look at Martin Smith's notes of the same meeting. Those are at poll 001-39866. I think you've said that Martin Smith was a competent note taker,
Yeah.
I think.
I think so, yes.
If we go over to page 2, I'm just going to read to you what looks like the discussion of the cultural issues. It says, Simon, we discussed last Friday, main problem is cultural. People in different departments needs to be a proper coming together. Rod says, a lot of issues not important, e.g. turn computer off and then on again, and then things which may affect continuity still need a steer. You say, we said we would write a protocol, roles and responsibilities, etc., centrally archived, owners of issues, and then it says QC refers to a couple of non-identified individuals, referring to Simon Clarke's advice on disclosure and duty to retain. Simon, think Paul have resolved those issues. QC says different individuals on call. Susan Crichton then says people then dump something. Is that likely to be the extent of the discussion about your advice on disclosure at that meeting?
No, these I think are shorthand notes.
Can you assist us with what Mr. Altman may have been talking about there where it says refers to a couple of non-identified individuals?
I think that has to be Andrew Parsons and John Scott.
Do you think that if this is an accurate note of that meeting, the issue was, first of all, not dealt in any great depth and also somewhat minimised?
No, I don't. It certainly wasn't minimised. There's a reference here where Mr. Altman says refers to a couple of non-individuals referring to advice disclosure due to retain. That's clearly referring to the shredding advice or the stop shredding advice. My response, I think Pol have resolved those issues, is my response to I think Pol have dealt with John Scott and there is no shredding going on.
The Bond Dickinson minutes that we saw, so if we go back, please, to poll 00006485, and that confines the issue to that one paragraph that quotes cultural issues.
Yeah.
Do you think that their minute of this meeting was in some way minimised about the description? I mean, to begin with, I think there was some criticism of Bond Dickinson lawyer in respect of the retention of information.
There was.
So to what extent do you think that paragraph was intentionally brief?
It would be speculation to be firm about that, but it certainly looks as though there's minimisation going on there. I would agree with your proposition that they are not telling the whole story.
I'm now going to look at the protocol that you drafted. That was poll 001289993, please. So this is the protocol. Was there a protocol earlier then, before the information you had been given about shredding, or only after?
I believe this is it.
And were you specifically instructed to do this, or was this another piece of work that you were carrying out because you thought it was necessary?
The latter. I did it because I thought it was necessary, and I thought it was necessary because I thought Post Office needed guidance on how to conduct the issue.
And it's entitled Protocol for the Conduct of Wednesday Morning Telephone Conferences held for the purpose of the identification, recording and retention of material which may be subject to the duties of disclosure. You set out in the preamble how very important disclosure is to the criminal justice system. And then in the first substantive paragraph, you say, as a prosecutor, Post Office Limited is under a positive duty to identify, record and retain any information which might assist a defendant in preparing or presenting his case, or which might undermine the prosecution case against him. In addition, we must also be able to prove that where we rely on information provided by Horizon Online to prosecute, that system is reliable and accurate, etc. Now, in terms of the first, is this in some way you and Cartwright King making clear that in criminal cases the duty of disclosure is very different to civil cases? Was that one of the purposes of this preamble, for example, reference to the criminal justice system?
I don't think the civil protocol was in my mind because I didn't know or understand the civil protocol. This was me saying to Post Office, as prosecutors, this is your duty.
We see there reference to Horizon Online, and if we scroll down to the third paragraph, it again, the final sentence of that paragraph says, accordingly, we will in future collect and retain any and all information which might suggest that Horizon Online may not be working as it should, or that our training and backup systems are less than we would wish. Now, I appreciate that any future prosecutions would, of course, be based on Horizon Online, but was there at that stage a bit of a blinkering in respect of legacy Horizon and a focus limited to Horizon Online?
No, this was looking forward. The whole function of this hub was to deal with disclosure duties going forward, and therefore any issues with the Horizon system generically would have arisen out of Horizon Online because that's a system that was in use going forward. This bore no relationship to, I think they called it Legacy Horizon, because they weren't using Legacy Horizon.
At those meetings, though, people could bring forward issues that related to Legacy Horizon, couldn't they?
I would certainly hope so.
And this policy doesn't mention Legacy Horizon at all.
No, because it wasn't directed to Legacy Horizon. It was directed to collating and retaining and disclosing material which arose out of the use of Horizon Online looking forward.
Do you think that there may have been a lack of interest or a lack of thinking about the impact on those legacy cases?
Not for this, because this was a wholly different purpose, but to answer your question in a more general sense, I think possibly yes.
And although I appreciate that this is for going forward, does it not reflect, in general, that attitude that the focus at that time was on Horizon Online?
Just going back to what you suggested earlier, you used the phrase lack of interest and blinkered. I don't accept lack of interest. I accept blinkered. Yes, we were looking forward. I'm not convinced I agree with you about whether this document reflects that blinkered approach, because this document was produced for a specific purpose, the specific purpose being the collation and retention of material derived from Horizon Online looking forward. And so I separate that issue out from what had gone before. But I again say, I accept your criticism that goes, you were being a bit blinkered about what had gone before.
I'm going to move on to a different topic, and that is the redrafting of the Post Office prosecution policy.
Yeah.
You've addressed that in your witness statement. In fact, perhaps we could bring that onto screen. That's WITN 081300100. And it's page 23. Page 23, paragraph 67. You say that, I think that's in some point in mid-2013, you can't recall when, you asked Martin Smith to obtain a copy of the Post Office's formal prosecutions policy. Martin Smith asked Jarnell Singh to send a copy, and in due course you were provided with a copy of what you considered to be a wholly inadequate policy. You therefore commenced drafting a detailed policy intended to at least meet the standards set out in the Code for Crown Prosecutors, including the then two-part test for commencing a prosecution. Was it surprising to you in mid-2013 that Cartwright King didn't hold a copy of the Post Office's prosecution policy?
Yes, this was part of my ongoing learning process early on in my involvement in the whole of the Post Office work, if you like. And at some point it occurred to me, I need to see what their prosecution policy was. I asked for one and was told that there wasn't one with Cartwright King. So I said, well, Post Office must have one, and I asked Martin Smith to obtain one from Post Office.
And as a firm that had by then been prosecuting Post Office cases for a few years, was it surprising that the firm didn't hold a copy?
Yes.
And you've described it as wholly inadequate. What in particular stood out as being wholly inadequate?
Oh, all of it. It's. Do you know, you see sometimes, and it happens in this case occasionally, a badly photocopied document so that, I remember it distinctly, so that the wording is at a slight angle to the edges of the... This is what I received, a single A4 document, badly photocopied with slanting writing and writing on both sides. I can't remember what it said, but it wasn't a prosecution policy. It had that title, but it wasn't a prosecution policy.
What do you mean by that?
Well, it just wasn't.
I mean, you say there that you drafted a new policy with the two-stage test, for example. What was the test set out?
Oh, the code, and that? There wasn't one. There was no test. There was no threshold test for whether or not you ought to consider an investigation and a prosecution. There was no basis upon which any sensible solicitor could say, we will apply this, and if the answer comes out, yes, we'll prosecute. If it comes out, no, we won't prosecute. There was. I can't recall what it said, but it was not a prosecution policy.
Could we please look at the policy that you drafted? That's at Pol 000030686. It says effective from the 1st of November 2013. So is that likely to be the kind of time that you drafted the policy?
I would probably look. I would have been looking forward a couple of weeks or a month, so this would have been drafted. If that says November, September, October-ish, I think.
Thank you. Could we please turn to page 6, where you set out some general principles. You say at 3.2, the decision as to whether to prosecute in a particular case or to continue with any prosecution will always be taken by Post Office Limited. And then you say the decision taker will be, 1, a qualified lawyer, 2, independent of any Post Office Limited department having a direct financial or other interest in the prosecution. And then if we scroll down, we can see the footnote 8. It says, this practice mirrors the approach of the Crown Prosecution Service and is designed to ensure that the decision to prosecute is taken by someone who is independent of the victim/loser and of the investigation. What awareness did you have of who actually was the decision maker in post office prosecutions prior to this policy being drafted?
I recall asking Martin Smith. I didn't really get a coherent answer. I don't blame him for that, because I think he didn't get a coherent answer from those he asked at Post Office. But the distinct impression I got was that John Scott had some sort of say in it, and I thought Roderick Williams had some sort of say in it, but there was never a clear answer given to me.
Were you concerned at all as to whether decisions have been taken outside of the Post Office, not by the Post Office?
I had no evidence to support that. It didn't occur to me that that might be. Well, when you say outside, what?
Well, let's say Cartwright King were carrying out prosecutions for the Post Office.
Yeah.
We're discussing here the decision to prosecute. Did you have any concerns that Cartwright King themselves may have actually ultimately been the decision maker in a decision to prosecute because of a lack of instruction?
In terms of straight line thinking, Cartwright King would, as I understood it, advise Post Office as to whether or not a prosecution ought to proceed, and Post Office would respond yes or no. In reality, I rather suspect your alternative is quite likely.
And what do you mean by that?
I mean, it is likely that in the absence of clear instructions from Post Office, Cartwright King made a decision themselves. But I hasten to add, forgive me, I had no direct evidence of that. I was looking backwards at what had gone on before my time, but that is a distinct impression that I have.
Thank you. Ultimately, I think the Post Office asked Mr. Altman to draft the policy. And I think you have said that you took a more prescriptive approach than Mr. Altman. Can you assist us with what you mean by that?
Yeah, I disagreed with his policy. I felt, well, first of all, I felt that a prosecution policy ought to have discretion where discretion was merited, but there ought to have been certain hard and fast rules as well, particularly about thresholds. And I derived that from the Code for Crown Prosecutors, which works in exactly that way. It provides certain areas of discretion, but there are some very hard and fast thresholds. And when I saw Brian Altman's draft policy, and it's clear in some of the advices I wrote, I rather thought he was watering down some of those hard and fast requirements that should have been there. I didn't agree with some of what he said.
And was that in some way due to your understanding of the way that the Post Office worked? Was there something specific to them that required hard and fast rules, or was there some other reason why you thought it was important?
I wanted the Post Office policy to reflect general public policy, and general public policy was set down in the Code for Crown Prosecutors, and I thought that the Post Office should, at the very least, set itself at the same level as the Code for Crown Prosecutors, if not more so.
We can very briefly look at the advice that you gave at Pol 001252210. There may have been more responses to Mr. Altman's draft policy,
Yeah.
but this is what looks like a more formal response. And if I could please turn to paragraphs 5 and 6 on page 1, the bottom of page 1. You say as follows, you say, in considering the formulation of this policy, we observe that whilst the principles to be applied are clear and concise, much of the policy is couched in terms of generality, so that a decision maker is here granted a wide discretion in interpreting and applying those principles. Such a wide discretion, whilst advantageous in some respects, may in fact provide unhelpful consequences for any decision is open to review, and the wider the discretion granted to the decision makers, the more amenable to review the decision will be. Can you assist us with, is that the same concern? And as I say...
I'm being polite about it, but that is that expresses the concern I've just expressed to you.
And was there something particular about Post Office that caused you a concern giving them wide discretion, or was it a general concern that that's just simply how it should be in a criminal prosecution?
It was my view as to how a a prosecution policy ought to work. And I go back, you may recall from one of the advices I wrote about this, is that in drafting the policy I drafted, I had considered not just the Code for Crown Prosecutors, but I'd obtained copies of the policy used by the RSPCA, for instance, and I think the NSPCC, who are recognised prosecutors, or at that time were recognised prosecutors, and one or two others. And I sought to distill all of those into what I hoped was a proper policy for Post Office. I was disappointed when it was watered down.
So I'm going to move on to a new topic, so that might be an appropriate time to take our lunch break.
Yes, by all means.
Thank you very much. Perhaps we could come back at 1:55, please.
Yep, fine.
Thank you.